Good evening, ladies and gentlemen. Thank you so much for joining us for tonight's edition of HR Mentorship Learning Series. My name is Oluyemi Adeosun, and the topic we'll be looking at today is contingent workforce management and attendant risk. Our facilitator is a regular speaker on this platform. Is Emmanuel, and I would just like to read his profile just for the first time via this platform. Emmanuel is an employment and industrial relations advisor at Renaissance Africa Energy Company Limited, formerly Shell Petroleum Development Company Limited. Prior to joining Renaissance, Emmanuel was senior associate with the Dispute Resolution and Labor and Employment Practice Group at AELEX. He was called to the Nigerian bar in 2015 and has amassed significant experience in civil litigation, labor, and employment advisory. Prior to taking a full HR job, Emmanuel frequently represented employers in defining labor and employment litigation at the National Industrial Court of Nigeria, Court of Appeal, which is the final appellate court in labor and employment adjudication, as well as the African Union Administrative Tribunal. He has also handled commercial litigations in Nigerian courts, Court of Appeal, and the Supreme Court. His labor and employment dispute experience encompass cases on wrongful termination, severance pay, exit, bullying, harassment, victimization, redundancy, labor union rights, labor union elections, occupational injuries, among others. Ladies and gentlemen, he has also handled commercial disputes, instituting, prosecuting, and/or defending claims on behalf of multinationals and international oil and gas firms. Emmanuel has advised on a broad range of labor and employment issues, including redundancies, employment reorganization during corporate restructuring, and representing client interest in negotiations with trade labor unions. He constantly drafts, reviews employee handbook for both local and multinational companies in diverse sectors in Nigeria and advises on the potential legal risk arising from the provisions of handbook, providing practical solutions to burning issues. Emmanuel was a co-contributing editor to the Nigerian chapter of the Employment Law Review, a UK-based publication in the year 2022. He is also a contributing member of periodic updates on varied spectrum of labor and employment law, including diversity and inclusion in the workplace, workplace gender rights, and general employee rights in Square Patton's blog online publication on labor and employment and a number of employment-related publications. Emmanuel regularly speaks at events and radio shows, including the Charter Institute of Personnel Management of Nigeria, the office, on Lagos Talks 91.3 FM, and the weekly HR Mentorship Learning Series for HR professionals. Emmanuel was ranked as a national leader in labor and employment by Who Legal Independent Research with clients and peers. He is a member of the Nigerian Bar Association, Employment and Labor Lawyers Association of Nigeria, African Labor Law Society, and International Bar Association. Because I've lost record, I'll say for the umpteenth time on this platform, let's welcome with pleasure Barrister Emmanuel Abraye as she facilitates on the topic contingent workforce management and attendant risk. Thank you for gracing us with your presence and wisdom once more.
Thank you very much. Thank you very much, Mr. Adeosun. It's always a pleasure to be here and welcome everyone to tonight's session. We'll be looking at the topic contingent workforce management and attendant risks. My name is Emmanuel Abraye and I'm an employment and industrial relations advisor at Renaissance. Today we'll be looking at what contingent workforce is all about. So I'll start by introducing us to the concept of contingent workforce. We will define certain terms. We would look at the various forms of contingent work. Then we will then drill down into the nitty-gritty of how the relationship with your contingent workforce and your regular workforce works in what is known as triangular employment relationships. We'll then look at certain risks that are associated with contingent workforce, including co-employment risks and misclassification risks. Then we'll go ahead to talk about how you can hedge these risks to see how to protect your organization. Of course, as we all know, the world of work has evolved. It is not how we used to know it, if I would say it that way, you know. Um, it used to be, I mean, we've passed through quite a lot of um, forms of work. I mean, at some point it was slavery. Later on, in the various industrializations that we have experienced, there have been several kinds of forms of work, from the agrarian economies to the industrial economies to the post-industrial economy, which is one of what we're experiencing now. So as I said earlier on, we've workers have had different kinds of names. At some point, we were all just a factor of production, land, labor, entrepreneur. What's the other one? I think there were four, but beyond that, we're no longer just factors of production anymore. We've moved from the time when we were just slaves to the time when workers then became known as servants, to the time when they became known as workers, even here in Nigeria, because the term worker has a distinct definition under the Labor Act, right? And to the time when we then became employees, and a lot of persons were fixing some relevance, their own relevance, to the fact that they were employees. And to the point now where work is now tilting towards what is known as sole corporations, where everybody wants to be their own boss, fire any other person who is claiming to have the role of a boss in their life, and then become their own sole corporations, which has now led to a phenomenon known as precariats, because we then have quite a lot of people in one form of precarious work or the other. And becoming sole corporations have not necessarily played out so well for so many people, so that you would then have people who are now known as independent contractors, people who are now known as freelancers, people who are doing one kind of work or another, supposedly, you know, as a solo person. But then when you drill down, you find out that they are all just employees who have just chosen to wear the tag of precariats. So this workforce is now diverse, so that you would have, in a particular workplace, you'd have different types of workers in that employment. You'd have full-time employees, you'd have part-time employees, you'd have fixed-term employees, you'd have short-term employees. All of these employees in the same workspace, doing one thing or the other. But for today, we'll focus on contingent workforce, and we would then define, what all of this means. Contingent work is where we'll start. What is contingent work? Because I recall that a few weeks back, I was on another webinar where I was the moderator, and then we had, quite a number of persons attend, some senior advocates, and, some judges of the National Industrial Court, and, people in the various industries as well. And I recall, one of the panelists was going to answer a question about contingent workforce, and he said, "Oh, that's the first time I'm hearing it. So that it will be easy, let's just quickly drill it down from the start." I know in many of your organizations, you have names like contract staff, you have names like short-term employee, you have full-time employees, you have part-time employees, you have fixed-term employees, you have independent contractors who are doing some kind of work for your organization. Now, all of these persons who are not full-time employees, who are directly employed by the organization, are the ones who we know as contingent workforce, right? So now what's contingent work? Contingent work is, it refers to an employment relationship that's temporary. It's temporary in nature. It's characterized by limited job security and typically it's characterized by part-time hours. That means the person in the contingent workforce is really not a full-time employee, so to speak, even though we'll come to some aspects where you'd find that contingent workers can be full-time employees as well. Now, who is a contingent worker? A contingent worker is a person who works for a company that is different from their own direct employer. I will come there because I'm going to show us a diagram that shows how this relationship works in practice. Right? Contingent workers, as I've said earlier on, could be self-employed. We talked about the concept of the sole corporation, where you have someone claiming to be their own boss, right? They could be self-employed, they could own businesses that provide services to companies like independent contractors. But the good thing, or the main thing you should understand about contingent workers, is that they are usually hired for specific tasks or projects, right? Now let's define contingent workforce. What's contingent workforce? Contingent workforce is that labor pool that consists of people who are hired by an organization other than the principal company for a fixed period and often on a project basis. This is the simplistic definition of what contingent workforce actually is, even though in practice we might have other forms of contingent workforce that do not necessarily resemble what we are considering tonight. Now, contingent workforce management on its own refers to, you know, or involves the overseeing of non-permanent workers like your freelancers, like your contractors, like your contract staff to optimize their integration into an organization while ensuring compliance, efficiency, and risk management. In fact, one of the most important things we're going to consider tonight is risk management, because if you do not hedge the risks that your contingent workforce portends, it could put your company in some serious trouble. Of course, we've been saying a lot of what we know constitutes the contingent workforce, right? So that we just remove any bias from your mind about what contingent workforce is. It's really all these names we've been mentioning before: contract staff, outsourced staff, short-term or fixed-term workers, personnel leasing, right? Freelancers and consultants, pool workers, who are basically just calling workers who are not employed by labor contractors. Sometimes you have people coming on a locum basis. They're just taking up this job because the person who actually does it has proceeded on leave for maybe 2 months, and then work has to continue going, and then the organization has to employ somebody to just fill in for that short period of time. That's usually a calling worker. And then you also have independent contractors. There are many other names. These are the major names, but of course, we live in a world where, you know, the names, we are never short of names, right? Names keep coming up, and we keep getting new descriptions for the kinds of works that are being done in our various institutions. But one thing you should note about contingent workers is that the employers of the contingent workers are the ones who are expected to manage all the incidences of the employment of these workers. And I would get to that place where we'll talk about what the risk would be when it is not that person who is managing the incidences of the employment. So, but the forms of contingent work that we have are already all these things that we have now, spelt out. I'll go over them again just so that if there's anyone just joining, you can as well, get to where we are. We've said that contingent work is nothing fancy. It's basically what you know as your contract staff, your outsourced staff, your short-term and fixed-term workers, personnel who are leased to you for a short period of time from another organization, freelancers and consultants, pool workers who I have defined as calling workers who are not necessarily employed by labor contractors, which is a term I will still define later on in this, as we go on in this topic, right? And then we also talked about independent contractor. The very important thing that I want us to drill down upon today is the concept of triangular employment. And I know it's not strange to us, right? Because many of us have, attended seminars or webinars where the concept of triangular employment would have been espoused to us. Why it is important for us to talk about triangulation of employment is because you cannot talk about contingent workforce without talking about triangulation of employment. The reason why the workforce is contingent is because there is another workforce that is in place, right? Which then creates a situation, that we'll now look into now. The point I'm trying to drive is that in industries or in endeavors or companies, institutions where you have contingent workers, there are always workers who are not contingent workers, right? Where you have a contract staff, there is a non-contract staff who is a full-time employee who enjoys all the benefits of, being a full-time employee, as against that employee who is a part-time employee and may not enjoy all the benefits of, the employment. Now, newer forms of work have birthed what we know as the triangular employment relationship, and it has arisen from the outsourcing model. Don't forget that we have talked about outsourced workers as part of the contingent workforce. Now, the parties in the relationship in this triangular employment are the labor contractor, who is basically the person who is providing the worker, not providing the service, but providing the worker. Now, apart from the labor contractor, you have the contingent worker himself or herself, who is the employee, and then you have the end user enterprise. I have decided to use these names because they are actually self-explanatory. When you talk about the labor contractor, is the person who holds the contract to supply the labor. And then you have the labor that is being supplied, who is the employee, the contingent worker, and then you have the end user enterprise. When you talk about someone as being an end user, you mean that that person is the one who takes the benefit of the workers that have been supplied and who then provide the service that's, the employment service that's required. Now, the way it works is that the labor contractor would hire the employee and then deploy that employee to the end user's enterprise to work there, right? Now, even though the labor contractor has deployed that employee, the labor contractor would then continue to manage all the incidences of the employment of that employee, all the incidences of the contract of that employee's employment. This is what is ideal. Of course, we're going to get into what happens in practice, and we're going to have to show us why those things that are actually done in practice can be very risky, right? Now, what are the incidences of the employment that are being managed by the labor contractor? It's things like salaries, benefits, pensions, discipline, performance management, and every other EVP metrics that you might have in your organization. That's the employee value proposition that you might have in your organization. Now, note that if you're doing something different in your organization to where you're the one hiring that contingent worker directly, you would be creating the risk of discrimination in your organization. Now, you must understand that the concept of casualization is something that's actually being frowned at. That is why you would find out that in banks, in the oil and gas sector, for instance, where you have the use of a lot of contract staff, you would find out that it's it's unlikely that you would find them hiring those people directly. They will usually have a company who is their primary employer, that is the labor contractor who employs that contingent worker, right? And then we'll go into a lot of things that, and I hope that many of us will take the learning back to our organization so that we can see where we are actually going wrong. What you must understand is that in this triangular employment relationship, the end user enterprise is not a part of the relationship between the labor contractor and the employee. In the same way that the employee is not a part of the relationship between the labor contractor and the end user enterprise. Now, what usually happens in this relationship is that the labor contractor and the end user enterprise would enter into an agreement, which could be a master services agreement. It could be an SLA, which is a service level agreement, that will just be an agreement between themselves, to draw up the terms of the employment. Now, the employee is not privy to that master service agreement or the service level agreement. He cannot draw any right or take any benefit from that particular agreement. Then you now have, at a granular level, the employment contract between the labor contractor and the employee. The end user enterprise has no business with that contract of employment, which is what is known as the principle of privity of contract. Now, the privity of contract concept is a legal doctrine that states that only parties to a contract can enforce the terms of the contract or carry out any obligations under the contract. That means that the third party, any of the third parties, would not be involved in the contract or acquire rights under that contract. Now, I want us to look at this diagram very well, the diagram that is now on my screen. It explains the concept of triangular employment, and it also shows, sorry about that, it also shows the risks that can be can arise out of that employment. Now you will see that there are three parties here. You have a party known as the labor broker, is the same as the labor contractor I was talking about. You have the casual worker, and you have the employer. The employer is the end user enterprise. The casual worker is the contingent worker. And I decided to use this particular triangle that you're seeing on your screen because it actually speaks to exactly what happens in our day-to-day life. And of course, the source of the triangle is also there at the bottom of my slides. Now, the way this relationship works is that the labor contractor provides employees to the employer. The employees provided are the ones who are the casual workers that you can see here, contingent workers in this case. This contingent worker is paid by, I don't know if you can see my cursor. The contingent worker is recruited and paid directly by the labor broker. Now, this labor broker is a temporary employment agency, and interestingly, many times they don't even have offices. Very, very funny, right? Now, the labor broker would supply the employees to the employer and will be paid by the employer for the employees they've supplied. The employer is the one who needs the services and is the one who uses the services. Now, you would see something that has been written here. There is no formal relationship between the employee and the employer. Sorry, there is no formal relationship. Let me say it the way it is on the slide. There is no formal relationship between the casual worker and the employer. The relationship, as you can see, the arrows are, double directioned, right? On the left, you have the fact that there's a relationship between the labor broker and the casual worker. On the right, you have the fact that there's a relationship between the labor broker and the employer. But you would see that there is zero relationship between the casual worker and the employer. And I would go on to explain why that is. If you're going to use contingent workers in your organization, the major risk you want to hedge against is the risk of casualization. Now, because if you directly employ these people and they are earning, because that's always the case, they tend to earn lower. Sometimes they do the same level of work, and we'll see why that is dangerous as we move forward. They do the same level of work, they put in the same level of hours, and in many cases, they work the same number of years, so that you'd find a situation where XYZ Bank has 400 contingent workers, who are actually casualized, and they work 8 to 5, sometimes 8 to 10 p.m., right? Like their full-time staff counterparts. And it's still that same lower pay that they receive as against what the full-time employees earn. You would later understand why this practice is actually dangerous for those who are, involved in it. But the concept of the triangle is just to show that there's a tripartite relationship, right? And this tripartite relationship is not a tripartite relationship where the three parties are at unity. It's a tripartite relationship where it's really just a conglomeration of two bilateral relationships, but just because there is a focal point where the services are being provided, right? And that is why you have that as contingent, workforce. Let's just move on. The main risk that you want to avoid in your contingent workforce practice is the risk known as co-employment risk. And I will explain it. We had earlier talked about the principle of privity of contract, where we had said that, look, it's only the party who is named in the contract or who is a party to the contract that can benefit from it. In co-employment risks, sometimes you would find that the contract is being controlled by a party who is not supposed to be controlling that contract. And I'll explain it. So for instance, we said earlier on that there are certain things that are features of contingent work. We said that for a contingent worker, all the incidences of his employment must be controlled by the person who hired him. So if a labor contractor hires a contingent worker, the contingent worker's salary will come from the labor contractor. The contingent worker's discipline will be affected by the labor contractor. The performance of that contingent worker will be managed by the labor contractor. The moment the end user enterprise, that is the principal company, begins to take decisions as making maybe discretionary payments to the contingent worker, or even paying the contingent worker's salary, or taking up, compensation, for injury on behalf of the contingent worker, or, disciplining that contingent worker, or managing the contingent worker's performance, there is now what is known as co-employment. The reason is this, and we'll get there, but let me just say it ahead. The court would not look at what you have named your contract. The court will go beyond what you have named your contract to interpret your contract by what is actually performed. And many times people do not know this. And that's the reason why, there's a lot of complaints when, okay, I don't want to instigate people to sue their employers, but I mean, you would see the point as we go on. So now the principle of privity of contract places a limit on the end user enterprise. The incidences of employment are contractual in nature and cannot be controlled by a third party to that contract. The end user enterprise is the third party in this, explanation have been given. Where the end user enterprise goes beyond its remit to control the incidences of the contingent workers' employment, that end user enterprise has then become a co-employer of the outsourced employee or the contingent worker, and would then be liable for breaches of the contract of employment or enforceable practice arising out of that tripartite relationship. How do we then know when the co-employer risk has crystallized? There is a test known as the control test, and this is what I've also been saying before now. That control test is crucial to determine whether a labor contractor and end user enterprise are co-employers. And this would also extend to independent contractors. And I'll tell you how. There's a slide for that as well. Now, I've said before that there's a doctrine of primacy of fact, which says that, look, it is not the name you've called your contract that matters. It is what has actually been performed in the contract that actually matters. So, what are those instances or when a co-employment risk could be said to have crystallized. If the end user enterprise pays salaries and benefits directly to the employee, then a co-employment risk has arisen. It means that at that point, the employer of the contingent worker is no longer just that labor enterprise, labor contractor, but it's the labor contractor and the end user enterprise, which means that a contingent worker can then start bringing claims like discrimination, right? That they've been discriminated against on account of the fact that they are earning less, they are, they don't have as much benefits, they don't receive as much in benefits from the organization, and that the organization is just using them as, you know, factors of production, so to speak, right? So when the end user enterprise also disciplines and outsourced employees or manages that outsourced employees' performance, a co-employer risk has also crystallized. Now, very important for us to note is that the law does not allow you to fill your core job roles with contingent workers. Your contingent workers are reserved for non-core roles. So when your non-core roles are resourced with outsourced employees, you have crystallized a co-employment risk. So when non-core jobs resourced with outsourced employees are even also placed on your company's organogram, a co-employment risk has crystallized. Because again, when you're designing your organizational structure, you want to ensure that you have roles that are strictly core jobs. Now, the luck we have in Nigeria is that the relevant laws and the guidelines, for instance, the guidelines on contract staffing that was issued by the Federal Ministry of Labor and Employment, does not define what core jobs are, right? So many times some employers might say, okay, well, this is not a core job, even though it is a core job. Now, whether or not it's a core job, if you place a contingent worker's job on your org structure, you have created a co-employment risk. And if you fill a core role with a contingent worker, you have also created a co-employment risk. If you give work tools to a contingent worker, because let me tell you, the guideline on contract staffing says that if you give job tools to a contingent worker, that's no longer a contingent work. So the job tools should actually be given to the contingent worker by their own direct employers, that's the labor contractor. So if you give laptops, sometimes even email addresses provided for the use of outsourced workers, you've actually created, a co-employment risk. If short-term non-core jobs are occupied by the same contingent workers and you continuously renew these short-term contracts, let me explain this very well. And it is very important that you take note of this because sometimes we have this set of workers who have worked in the company for 20 years, but they've worked under one form of short-term contract, fixed-term contract or the other. So you're renewing a yearly fixed-term contract or a quarterly short-term contract or a 6-month fixed contract for this person. And you have been doing that constantly for several years. You have already created a co-employment risk, especially when you are rotating those workers amongst different labor contractors. So today, this worker is employed by ABC Limited. Tomorrow is employed by XYZ Limited. Next tomorrow is employed by Manu Limited. And you just create that string of employment for the person. Meanwhile, you have been the end user of that person's service over the period of several years. The courts would say that a co-employer risk has arisen. In fact, the court would say that you are the employer of that person. You are only trying to disguise. And it is these disguised forms of employment that the ILO frowns at. Now, there is this new concept where people create a chain of command across several companies. And I'll explain this one because it happened in a case that I handled. Uber has a structure where someone in Nigeria can be maybe head of legal sub-Sahara Africa, right? And then that role reports directly to a line manager. Maybe that role reports first to a line manager in Nigeria, a second line manager in South Africa, a third line manager maybe somewhere in Kenya. And then the person will then have benefits that are given to them by the, you know, principal company, maybe the holding company, and they're giving them stock options. And then when this person sues, the principal company then comes to say, no, this person is an employee of Uber Nigeria, is not an employee of Uber San Francisco. That would just all be, the court will take it to a pinch of salt. And that's really what happened in this case of Sheikh Wadrago versus Uber that you can see on your screen, right? The court refused to accept the argument that the employee was a local employee, especially because the person who even came to give testimony as a witness carried the title of legal manager sub-Saharan Africa. Nigeria is not sub-Saharan Africa. You cannot claim that that employee was just. So when you create organizational structures that do not necessarily suit the reality of your day-to-day work, it could create um co-employment risk. And I don't I and I hope that was very clear. For misclassification risks, this is also applicable in two instances, right? Where an outsourced employee is given work tools by the end user enterprise, that outsourced employee, beyond just the co-employer risk that we're talking about, can also be misclassified as a direct employee of the organization. And where that employee, quote and unquote, is actually an independent contractor, but operates in violation of a rule that the Supreme Court sets down in the case of Shena Security and Afropark, that independent contractor will be deemed to have been misclassified and will then be properly classified by the court as an employee. Now, there are instances, which are instances you should all watch out for when an independent contractor can be misclassified as an employee. The first is when you pay an independent contractor salaries. An independent contractor, even though a contingent worker, is supposed to work with your organization as an independent contractor, receiving payments for contractual work done, paying his own taxes, right, by himself because he's an independent contractor. And I want us to be very careful because there are some sweet names people keep throwing around. One that I came across recently was the use of a particular job role known as interim manager. Now, we use these interim managers, especially in instances where foreign countries or foreign-based companies want to operate in Nigeria, but they want to do so, in ghost mode. They don't want to be said to have a permanent presence in the country, right? So they then hire people in Nigeria and they call them interim managers, right? And then they say, oh, the interim manager is basically to just that interim manager is basically an independent contractor, right? They just want to change the name to make it look a little bit different, right? And then to place some form of uncertainty on the job role. And then they say the person is an interim manager, and then the interim manager has his own email address and all of that. But sometimes you rent a place for the interim manager to work from. The moment you do that, and then you give him a laptop, the moment you do that, he's already an employee. You only misclassified him as an interim manager. So when payments are made by way of salaries, when you provide an independent contractor with work tools or equipment of work, he is no longer an independent contractor, he's now an employee. When the independent contractor you have hired for a particular project or anything is not allowed to delegate the duties to someone else, he is not an independent contractor, he's an employee. When you fix hours of work for an independent contractor, that independent contractor is an employee. When the work being done by the independent contractor must be carried out on your premises, that independent contractor is an employee. When you provide an office space for the independent contractor, that independent contractor has now metamorphosed into an employee. Now, it is not that all of these 6 things that I have mentioned must be present in one single case. They don't cohere. When one occurs, the misclassification risk has already crystallized. And you then come to a situation where that person is no longer an independent contractor as you have called him or her, but the person has now become an employee. So these are the things that you have to watch out for to ensure that you are not, risking, misclassification or co-employment risks. Now, I feel like tracking back a little bit, just so that I can explain again the doctrine of primacy of facts. The doctrine of primacy of facts says that the court is going to be blind to what you have called your agreement. If you say that this person is not an employee of Global Heritage Nigeria Limited. I'm sorry if that's anybody's company. It just came up off my head. But it is employed by Abacha and Sons Contracting Services Limited. The doctrine of primacy of fact will look beyond the fact that the contract is actually between Abacha and Sons and the employee, but will look at exactly what has happened in the course of the employment to determine whether or not Global Heritage Limited is the actual employer or co-employer of that employee. In which case, if the court finds that this person is a co-employer or this entity is a co-employer, all of the benefits that this person has lost, the court will deem it that you discriminated against that person, right? Which is the reason why it is important for you to do the things that we have now listed here. To say that you should not pay salaries or any form of benefits or any form of compensation directly to your contingent worker, right? If you do, they are no longer contingent. They are now your full-time employees. In which case, if you are paying your full-time employees 5 million naira per month and you're paying the contingent worker 500,000 naira per month, you are owing that contingent worker 450,000 naira for the number of months that they've worked with you. And it's not even a joke. And I wish it was a joke. So many times you find that in your organizations, you treat these things trivially. You call certain persons contingent workers, but they are employed directly by you, right? That itself is a discriminatory employment. Everyone in Nigeria has the right to equal work for equal pay. Yes, in the Constitution, it is hidden in Part 2, which we say is non-justiciable. But don't forget that the National Industrial Court has the power to apply international labor standards, and that will include the African Charter on Human and People's Rights, which is even domesticated in Nigeria anyway, right? So you have to be careful to ensure that you're not blurring the lines between your contingent workforce and your main workforce, which are your full-time employees. We also said that you should stay clear of the incidences of their employment, pay discipline, performance management, and every other employee EVP metrics, right? Your value propositions, keep them far from it as much as you can, right? And then we said in designing your organizational structure, ensure you have core jobs and non-core jobs. Place your contingent workers on your non-core job roles. You cannot have a contingent worker who is doing the same work as a full-time employee. That's just discrimination. You're just discriminating against that person, right? It is not even that the person is actually a contingent worker. You are basically trying to get cheap labor. That's just what it is, right? So when you're designing, ensure you have your core jobs, you have your non-core jobs, and you place your contingent workers on the non-core jobs. Now, if you're feeling and the non-core jobs we are talking about, right? Don't even place it on your organogram. Your organogram should be filled with work, with jobs that are your core jobs required for, what you do. For instance, and this is not to discriminate against anyone, if you have um caterers who provide, maybe you outsource your catering in your company, and then you have a set of caterers who come in, they have their own employees. You cannot design an organizational structure that has caterers on it. It then means that you are the one creating the co-employment risk by yourself. You also cannot fill your core job roles with contingent workers, right? You cannot give work tools to contingent workers. And I know this can be a little bit difficult because you want to maintain a standard. You want to keep the level of your confidentiality at a particular place, right? You want to make sure that everybody is accessing the same IT systems, the same security levels, and all of that. Yes, you would always have to find a way to ensure that your IT guys can create systems that work, but still put that line in between your contingent workers and your full-time workers. If you have the habit of consistently you know, recycling contingent workers, and today they've worked 3 months with you. When the 3-month contract is ending, you already have a new labor contractor who is going to still hire them for another 3 months, and they've done 3 months of employment for 26 years. It's a Kasongo matter. I don't know if you know that worship song, Kasongo. Yeah, it's a serious Kasongo matter. Except that sometimes these people do not know how to um make their claims. Of course, we also talked about the fact that, when you have structures that run across different companies, you want to be sure to break that so you don't also create that risk of co-employment. We also went into misclassification risks to talk about, you know, um, how you should deal with independent contractors, particularly, because sometimes we say, oh, he's an independent contractor. Look at the contract that he signed with us. It's not a contract of service, it's a contract for service. See, the National Industrial Court has gone beyond that. I mean, in many of the classes that I have taken here, I have explained to you that the National Industrial Court is a miracle court that has the power to apply international labor standards to local circumstances. And I know that many times employers have said that the National Industrial Court is biased. The National Industrial Court does not, is not an employer's court, it's an employee court. It's because sometimes the employers are overdoing it as well, and somebody has to protect that employee, right? So you cannot say that someone is an independent contractor, but you're paying him salary. Then you did not remit taxes all throughout the period of his employment because he's not your staff. You didn't create social security for him. So no pension, no gratuity. But you say, oh, yes, it's because he's not our staff. Check the contract, check the contract. He is an independent contractor. That's when the court will now tell you that, look, I don't care the name you gave the contract. What I want to see is what was done in the course of the contract. So if you provide work tools to independent contractor, they are your employees. If you don't allow them delegate their work, they are your employees. You force them to repair all your cars inside your complex because you want to monitor what they are doing. They are your employees, they are not independent contractor. You provide offices for them. You say, no, it's just so that they will have somewhere to chill so that the sun will not scorch them. Leave them, they have their own office to go to. Allow them do that. If you do it otherwise, you'll be creating, a misclassification risk. Now, let's round off by looking at the ways in which we can hedge all of these risks. The first is to ensure that your labor contractors in that service level agreement or the master services agreement with which you have hired them to provide workers to you, ensure that there is your legal people putting a clause there that indemnifies the company from all losses and claims arising from the service provided and the employment relationship. You see, two things to keep you indemnified. When they say you should keep someone indemnified, is to keep them from any form of claims or harms or losses or anything. If anything arises from this contract, you, the labor contractor, bears that risk. And it is important because if eventually they sue, the employee sues, you can bring the contract to the court and tell the court that yes, even if this risk seems to have crystallized, this guy has indemnified me from the risk. So it's his risk. He has to bear, whatever is coming out of it, right? Then take off your company's non-core jobs from your organogram. Ensure that your company's organizational structure has only core jobs, not non-core jobs to be done by, contingent workers. The reason is because any job that is on your organogram is not non-core. Any job on your organogram is deemed to be a core job, which must be resourced to full-time employees, except that job is a proven short-time job. And you know, the relevant provisions of the law, particularly the contract staffing guidelines by the Federal Ministry of Labor, is to the effect that the short-term job must be proven. It's not the kind of short-term job that you just say is a short-term job and then you know it must be proven to be a short-time job that happens for a short time. That's why it's on your organogram and you still outsourced it to a contingent worker. If it's just Oboju you are trying to do, they will still catch you. Don't say I did not tell you. Now again, right, you must also ensure that your non-core jobs are the ones that are outsourced and performed by outsourced employees or independent contractors. And then ensure that the independent contractors are not allowed to violate the rule I just shared in Shena Security and AfroPac. Don't pay them salaries or benefits. Don't give them work tools. Don't give them an office space. Allow them to delegate if they have to delegate, right? Now, you may then have to redesign your organizational structures and limit chains of command to a single entity rather than allowing chains of command extend into two or more entities. This applies to those of you who are in groups of company, right? One person is employed by XYZ Limited, but he's working for 4 different companies. If tomorrow he wants to sue, he can sue all of you. And you cannot say he was not your employee rather, simply because his contract of employment says something else. And that is what many employees do. Their lawyers will tell them, look, the place they kept you are selling Google and Ekpa there, there's no money there. Let us sue the group company. And then the group company will file a preliminary objection and say, oh no, I did not employ him. He was employed by this other company. That is his employer. That is the person he should sue. They got to say, no, what actually was performed in the contract? Were you giving instructions to him from the group Or was it just that subsidiary that was strictly his employer and controlling his employment? Did you pay him salaries from the group at any point in time? Did you send him on discipline to the group office because you felt the group office was properly resourced to handle all of those things? These are things you want to look at to ensure that you're not creating risk of co-employment or risks of misclassification in your contingent workforce management. Again, ensure your company is not directly making any discretionary payment to outsourced employees, including employee stock options or shares. Many times I see this happen a lot. A person is employed by one company, but because that company is a part of a group, you know, the group will buy rice and send it. The group HR has approved that all employees would be given one bag of rice at Christmas. Oh shit, you have created a co-employment risk. That bag of rice is some form of compensation or incentive or something, right? So it works against you actually to do that. Now, if you have an SLA or an MSA, that's service level agreement or master services agreement between your company and the labor contractor, ensure that it is stated there that an agency has not been created. The reason why that is important is because of Section 91 of the Labor Act. Section 91 of the Labor Act adds agents as employers. So if you don't put it in your SLA or your MSA that the labor contractor is not an agent of the principal company, they will be deemed to be agents of the principal company. Now, when you are trying to resource contingent workers, and you know that this is a non-core job role, do not appear in the recruitment process. If you appear in the recruitment process, don't say you just want to sit in because you want to be sure who the kind of person they are employing for you, right? Be discreet during the recruitment process. Just give the labor contractors the specification of the kind of employee you want, the qualifications and all of that. If they don't deliver those kinds of people, then you know you have to look for someone else to do the work. Don't sit in on the recruitment and be asking questions during the recruitment, and then the person is wondering why they have a different contract from you when they resume, right? Once you sit in the recruitment process, you have already declared that you are privy to the contract, and then you bear liabilities from that contract. Then when it also comes to training and development as well, don't train your contingent workforce directly, right? Train them through your labor contractor. In fact, maybe you want to consider outsourcing your training to whoever. I don't want to advertise for anyone, right? And let them know that you have third-party beneficiaries to the training. Now, they will then register those labor contractors, right, under you. But then, in actual fact, in the relationship itself, the employee knows that the training he's getting is getting through the labor contractor and not through you. Of course, you want to make sure that the labor contractor has the capacity to discipline the employee, the capacity to set up, you know, disciplinary panels, right? You cannot take a labor contractor who only is using a smartphone, and this is not to broke shame any business, right? The job of labor contracting is a serious job, and it actually has to be taken up by those who can actually do it, right? Not to be taken up by somebody who just has a phone and a laptop and can prepare employment letter and just post people anywhere, or to just take chalk and write on the walls of people's houses, cleaner job, 500K, call me. And then those are the people you are now dealing with to provide your contingent workforce for you. What you're trying to save in cost, NICN will collect it back from you in cost as well, right? So all of these are the things through which, or the ways through which you can hedge co-employment and misclassification risks in our contingent workforce management. Um, Thank you very much. That will be all from here. So if we have any questions, I believe we can take them. But I would hand over to Mr. Adeosun before we have the question.
Thank you so much. This has been excellent. Thank you so much. Before I go to Oluchi, I have a question. Well, a request.
Right.
Can you speak briefly around internship specifically? Interns and internship specifically. And maybe
Right,
even
sir.
NYC a little.
Okay, sir. All right, sir. So here's the thing about internships and NYSC as well. We don't always classify them as contingent workforce. The reason is because, and again, don't forget that what I said earlier on is that it is what you practice that would be held against you, not just what the contract says, right? So interns, for instance, they come into the company, the purpose for which they have come, either they are coming as independent interns who are just the ones who have shown the interest in the organization to be trained by the organization, or they are sent by their schools to be trained by the organization, right? Whatever it is, leave them off your organogram, right? Do not attach any role to them. Ensure that everything they are doing is training. Of course, they would work in one way or the other, but it's still training, right? So that even if you've given them work to do, you have them coming back to fill their logbook or whatever book they come with to say, okay, this is how much work we have done for the day. Now, for NYSC, they're already paid by the federal government to come to your organization to serve the nation, right? The NYSC Act is actually quite clear on what they are to do. Now, that NYSC core member who has come to your organization is not your employee. In fact, do not make any room for them in your organizational structure. I know that many of us even resource core job roles with NYSC people. That is risky. The reason is because many of us then do that and then we then pay them, below market rate because after all, they are NYSC. Look, the why I would always advise us to be very careful about it is because you really don't know how, things like this are done in other climes, right? The International Labour Conference is going to be coming up next week, and we don't know what the discussions are going to be, or if there's another international labor standard that will come around something like this, right? It's just always good to be safe. Even if the persons are going to do work for you, design some form of training program for them so that when they arrive, they're actually being trained. So in some organizations, you would have them, you know, create graduate internship um, programs. That's the reason why they do that, to actually hedge some of these risks, right? So that someone comes, is actually a graduate intern. There's actually a program for him to run, right? Or for her to run. And as they run that program, they are also, applying their knowledge to real-time activities within the company, right? So that tomorrow they cannot go and claim that, oh, this person hired me and just hired me so that they can use me, and then they didn't even retain me, and all of those things. So um, don't put them on your organizational structure. Leave them as who they are, NYSC people who the country has, assigned to you to work, right? But keep them on a training level, and don't let them enter into your org structure so they don't create some of those risks for you. I don't know if that helps. Mr. Diosho. Okay, I'm not.
Thank you.
All right, sir. I see Aluchi's hand is up.
Good evening.
Good
Thank you
evening.
so much for this enlightenment. Like, we're all guilty. Like, it's scary. So my question is, how do you handle a situation where a non-contingent personnel, for lack of better word, gets into a fight or something with your core staff, like you're saying, don't do this, don't do that. So they have a situation in your work environment. How do you treat that? Because the fight has gone against your code of conduct.
So here's the thing. Your code of conduct. So let me explain it this way. What we call employment contract, right? It is not just that offer letter that you give to your employee when you're recruiting them, right? It is the offer letter, the employee handbook, and every other internal policy, human resource policy that are operational in the company. That is what forms the contract of employment. Now, the question you want to ask yourself is this: do you have a contract of employment with the contingent worker? The straight answer is no. Except if you hire that contingent worker directly, in which case you're already risking, a lot of damages. Let me just put it that way. But if that contingent worker is hired by a labor contractor, and because again, even in minus just having a fight, sometimes sexual harassment cases, it also happens between full-time employees and contingent workers, right? But what you do is you have to split the investigation and discipline. Even if you don't want to split the investigation, you must split the disciplinary process. You write to the labor contractor to inform them that, look, this your employee, let's say that contingent worker was the aggressor, right? You write to the contingent workers company to say, look, this is what has happened on XYZ day. Please see attached a preliminary investigation report, because you are not even allowed to make a decision. And then you advise them to investigate as well, so that even if your preliminary investigation will aid them, they still have an obligation to investigate. When they are done investigating, they then have an obligation to also effect the consequence management for that discipline on their own employee. There should not be any trace of your own company in the documents that would reach that employee. If there are, then you would have, created a co-employment risk by doing that. So regardless of whether or not the disciplinary issue in question is mixed, still split the process and ensure that you save your company from that as well.
Thank you so much.
You're welcome. Any other questions? I'm still available. I'm trying to look through the charts to see. So someone says, do you know that all of these rules are stated in NYSE column letter? Yeah, actually, yes. Yes, I agree with you. Someone says, are wage earners, those used for factory work gotten from outsourcing companies, also covered in this topic? Yes. Yes. So basically what we have said today is that in there are different types of workers in companies. There are workers who are directly employed by the company itself. There are workers who are employed by labor contractors, which means that the company has outsourced some of its work functions to that organization. What we have said in this study is that you should not, under any circumstance, outsource your core jobs to labor contractors. You should not have any outsourced employee filling your core job roles, except if it is a proven short-term role. Not a short-term role that you're using to use do that you just say, okay, 3 months. Oh, we want to renew your 3 months. Well, then after that one, we want to, and then someone ends up working for 15 years under a perpetually renewed 3-month contract. That one is not what we are saying. That one, when you even continuously renew fixed-term contracts like that, they actually metamorphose into permanent contracts, and the court will hold that they are now permanent contracts, and all those things that you were trying to prevent them from, that they will not get car, they will not get this one, they will not get that one, the court will give them more. I hope I'm not a bearer of bad news this evening, but that's just what it is. Someone says, can we draw up a contract staff policy? No, you cannot draw up a contract staff policy. You, as the main principal company, cannot draw up a policy for the labor contractor. Mind you, and I hope I said this, don't be caught in that ticket of casualization. If you have two types of employees where you have one full-time, one contract, that's a Kasongo matter, or is a serious one. You have to restructure your organization to either outsource the contract roles to someone else or regularize all your contract staff into your mainstream system so that you cure that defect before it creates an issue for you. So you cannot draw up a contract staff policy for the outsourcing company, right? The risks to avoid, if you don't do it, there's no risk to worry about. If you don't draw up that staff company, there is no risk to worry about. If you have contract staff, like I've said earlier on, outsource them, or you should regularize them. So if you're not outsourcing them, you should regularize them. Okay, I can see Uncle K's hand up. After that, I'll take the other questions on the chat. Uncle K, can we hear you? Okay, you're muted in case you're speaking.
Okay, thank you very much for this very powerful and insightful guide into HR workspace.
You're welcome.
As you know, HR is also the lawyer of the organization. Okay, there's this organization that I know has all its staff, perpetual all of them on contracts. Okay, then describe some contracts as long-term fixed-term contracts. Then they have some staff as short-term contracts. Okay, then so that they won't be liable, they also have casual staff contracts. So in how they operate it, they break the contract of the short-term contract staff. Now, these are not contingent staff, they are directly with them. Okay, they now break the contract like every 3 months. You must be deliberately break it and say, okay, you take like a month's leave or 2 weeks leave, then you come back and the contract becomes renewed. And then that could go on for eternity. So, I mean, does that really exonerate them or makes them culpable? Thank you.
Okay, thank you very much, Uncle K. So here's the thing. Sometimes you'd find organizations who, you know, um, are project-based, right? They are project-based organizations. They carry out projects for other companies, right? Not that they do it directly, right? They carry out projects for other companies. Now, to carry out those projects for the other companies, they need employees. Those projects that they carry out for those other companies are most times short-term projects, sometimes a year-long project, right? So they only need employees for the length of time that they have the projects for. I don't know if you
Yes,
understand.
I
If that
understand
is
you,
the
but
case,
that's not the case in this matter. That's not
okay,
the case. They
I'm
work
coming to the
directly with them.
yeah, I'm
Okay.
coming to the other side now. If that is the case, then that's a proven short-term contract, which nobody would question you for because you're only employing as you get work to do. If it is not the case, right, and it is just that they are, sometimes fixed-term employees don't have certain rights that full-time employees have. If it is just that they are doing that to ensure that those employees don't get the rights that they should get, then that is wrong, right? And HR should be able to advise them to do what is right. And what is right would be to regularize their contracts to full-term contracts. Else, the risk that organization stands, to suffer is that an employee can sue them to court for that employment to be regularized. And in many of those instances, I've found that those people don't pay taxes on behalf of their employees. They don't have any social security for their employees. There is no employee compensation regime for those employees. There is no pension for those employees. So when those things happen that way, right, it's left to the employee. And I know that many times when I say this, people say Emmanuel likes court too much. And I know I've heard it, but look, that's the hope of the common man. Unfortunately, fortunately, in the case of the National Industrial Court, so you can actually sue. It's just that in suing, you have to make sure that you retain the services of a lawyer who is skilled in labor and employment, because there are many branches of law, and you want to ensure that you're hiring the right lawyer for the right work. So I've seen some other questions. I don't know if that answers you, Uncle K. And I hope it does. Someone says, what if you hired a contract staff for about 10 years? What can you do now to correct your past errors? The good thing is that whenever you wake up is your morning. One of the good things that I find in situations like this is that you have to correct that error and hedge that risk and do it immediately. Many times when you regularize that person's employment, you want to also give them a mutual settlement agreement to say, look, we are now regularizing your employment. We are paying you XYZ amount of money as an ex gratia payment to be made to you. However, sign this mutual settlement agreement that you're not going to sue us. Of course, it will raise red flags, but if the employee signs it, that's one risk hedged successfully, right? Or just give him a new contract, regularize his employment, and then look into the contract of his his contemporaries or her contemporaries. What have they earned over the past 10 years that this person has not been given, even though the person has been doing the same kind of work? Look into it, draw up, some form of communication to the employee, and let them, see that you are now, trying to regularize their employment. And that is really something that I know would work perfectly well for those kinds of employees. I'm sorry, there's just been power off, gone off in my where I am. Now, can NYSC staff be covered under NHIS? I think they have their own insurance scheme that NYSC runs for them. Can you give your outsourced staff an ID card? Please, I think that we should be careful with this, because many times companies have their ID cards and access card in one document. Now you want to split that. It's good to give them access card because they need access to come into your place of work to continue their daily work, right? But do not give them ID cards. Their ID cards should be given to them by their direct employers, who is the labor contractor, right? You can merge your access card with the ID card given to them by the labor contractor. And in the service level agreement or in the master services agreement, you would state it there that, to hedge that risk, to say that access cards will be given to the labor contractors for them to print their employees' ID card on it, but should not mean that that ID card has been issued directly by the company. So do not give ID cards to outsourced staff. That's a work tool. Actually, that's a work tool, right? And it shows that you have an item of ownership that you have also given to them. Someone says, please help clarify. An outsourced company indicates in their employment letter that Ms. Lagwaja is posted to XYZ company. Does this make the outsourced company and the no? So let me just read the question company. Does this make the outsourced company and XYZ company co-employers? No. What happens that brings about the co-employment risk is that the end user enterprise, that's the principal company, now begins to take control of the employment of that outsourced employee. How do you take control of the employment of an outsourced employee? Number one, you start paying them salaries. You start making discretionary payments towards them. You give them benefits. You start giving them some form of compensation. You start giving them work tools. You start, managing their performance. You start to discipline them. When you start doing all of those things, you are now prying into a contract that is not yours. In which case, it means that you are now trying to manage a contract that is not yours to manage. that is when the co-employer risk begins to crystallize, right? Someone says, and I hope I answered that question, what about the situation where you hire someone above 60 or 65? Are there any risk associated with that? Can the person still claim to be a staff? So, of course, in the issue of retirement age is contractual, right? There is no fixed retirement age in Nigeria except for those who are in the public service, right? For those in private service, there is no fixed, there is no law that says this is your retirement age, right? But you want to be careful not to create the wrong precedent, because if you employ someone who is above 60 or 65, when your company's retirement age is 60, another person, there is a principle in law called expectation interest or legitimate expectation. This doctrine says that if you create a state of affairs which any other right-thinking person can lay claim to, you have created a legitimate expectation. Let me use an example for this. For instance, in this question, someone is 60 years old and your company's retirement age is 60 years old, and then you hire that 60 years old person to come and work for your company for a term of 5 years, right? You have created a legitimate expectation for the person who believes that, look, yes, so I'm 60, but I still believe that I can work. I still believe that I can provide services, right? And he says, I want to be treated the same way you treated XYZ person, right? Or sometimes when people retire, you give them, payments that are discretionary, but not contractual. And then you have done that for like 5, 6, 7 employees. And then one employee resigns because you don't like them, you don't give them the money. And then they say, no, why next down me? This other person that you gave the money on call, why are you not giving the money to me? You would not be breaching any contractual provision at that time, but you'll be breaching a legitimate expectation, and the person can actually sue on the basis of that legitimate expectation alone. In fact, on this principle of legitimate expectation, I will go a little bit further. A case I handled at the National Industrial Court. This lady was hired by Gokada. I can mention because the case is now public knowledge, right? And they poached her from Azamansad, and then promised her during the interview session a long and fulfilling career. And then 2 months into the employment, the global CEO of Gokada just wrote a post on this blog. Forgotten the name, but it was a common blog at the time. Just wrote a post there, and it turned out that they had declared redundancy and certain persons were fired, including this lady who was fired 2 months after being poached from Axa Mansard. And yes, she sued and said, no, you can't just fire me that way. And the court said, yes, we agree with you. That promise was made. It was a legitimate expectation, and the court gave her compensation for 10 months of additional salaries to make it 1 year, right? So you want to be careful with creating legitimate expectation or expectation interests in your contracts. Where do fixed term contract employees fall in all of this, where their contracts are renewed yearly? Again, maybe this person joined late, but a fixed term contract employee is a contingent worker. But we said when you continually renew fixed term contracts, right, you stand the risk of, making that person metamorphose into a full-time employee by your constant renewing. Because as you are renewing that contract, it shows that that role is a permanent role, not a temporary role. Contingent workers are meant to fill temporary roles that are not on your organizational structure, roles that are non-core functions, right? So if you are renewing someone's fixed term contract, it shows that that's a core job role which should have been resourced with a full-time employee and not a fixed-term employee. I don't know if that helps. Someone said I met a cleaner who has been working for 2 years now without a contract or file and paid below minimum wage. She doesn't have access. Kindly advise. I hope you're not the HR in this place, because if you're the HR, it's looking like as if you're now breaching CIPM's pledge. It's like we'll report you small. But no, that's just a joke. But seriously, you would have to stand up for someone like this. You cannot allow that happen, right? Even if she doesn't have SSC or GSC or whatsoever, the minimum wage is not qualification specific. If the person is a worker, the person ought to earn. But then again, there are limitations to this, the number of employees you should have and all of that. But of course, you can also be the person's advocate. Someone said HR is the lawyer of an organization, even though I don't know where the person got it from. What are the risks attached to putting employees on trainee without regularization? And also, what is the maximum period a training program needs to run before conversion to full-time staff? So the thing is just this, apart from undergraduates and NYSC people, every other person you put on a trainee role is a full-time employee. Please, so that you not say because they are still in graduate training, they are not employee. No, me so the person is a full-time employee, entitled to pension, to compensation and all of those things. That's injury compensation and every other terms of employment that you have your other employees being paid. It's just that if they do not succeed in the training after that graduate training program comes to an end, they may not then move to the next stage. I don't know how it's designed in your organization, but they are employees, please. And training should be for a reasonable time. I mean, there's no law that fixes, at least I'm not aware of one that fixes a duration for training. Can we give ourselves employees access to the company's Wi-Fi? Again, look, you can have different opinions about this, right? But work tools are things that aids work, that helps an employee work. If Wi-Fi is part of it, create a guest Wi-Fi. Let your full-time employees use whatever name you want to call it as a full, service Wi-Fi for all employees. Then your contingent workforce, their employers can give them Wi-Fi's, or you can create a guest Wi-Fi for them. I know someone laughed at that question, but it's actually a serious one. I recently employed a contract staff. I just generally drafted another employment contract for him. And of course, no unnecessary deduction whatsoever. In fact, his work is flexible. My brother, okay, my sister, please be sure that that person you have hired as a contract staff, you have not gone to say in that employment contract that they are a contract staff. That is discrimination. Ensure also that the role you've applied, you've hired them for, is not on your organizational structure or a core job in your organization. If you want to employ them as outsourced staff. If you employ them as contract staff, you are creating a risk for your organization. So please don't see the total cost of contingent staff is above minimum wage. However, the contingent staff gross pay is far less than minimum wage. Who is liable? I don't understand. If the total cost of contingent staff is above minimum wage, however, the contingent staff gross pay. This thing is looking like miracles that can only happen with spiritual intervention. How is the person's cost? I don't understand it honestly, but you want to ensure that you're not underpaying your contingent staff. And please, you're not the one to pay your contingent staff for. If you by yourself create a situation in your company where you have contract staff and full-time staff who are earning, eh, unequally, that is a serious problem you want to avoid. Well, I believe I've answered, except that I think I'm seeing another question. Total cost to the labor provider. Oh, no. So the total cost to the labor provider. So this person says what he's trying to say is that the total cost to the labor provider is above minimum wage, but the pay to the contingent worker is below minimum wage. My brother, it is the money that follows that employee home that is the minimum wage you are talking about, not the one you paid to the labor contractor, because That labor contractor work was looking very sweet to me. One time I almost set up a company to be doing it so that I can be collecting 40% or 60% of people's salary just because I gave them employment letter. So please, it's the person who is doing the work who should earn above that minimum wage, not the labor contractor, because again, your pay slips will show that the person is not earning, what they should earn. Of course, you want to also get further advice on minimum wage. All right, I believe that should be all from me. I'll now hand over to Mr. Adeosun.
One more question, sir. On behalf of, I'm asking for a friend. Please,
All
should
right,
minimum
sir.
wage be net or gross?
So as far as I'm concerned, I believe it should be net, and I have not refreshed my memory on the Minimum Wage Act in recent times. But I believe the intent of that law is not to create a loophole where employers would say, oh no, the gross pay to this employee is actually above minimum wage. It should be the net. This is one of those periods where we should allow our church mind prevail. Someone says it should be gross. Like I said, I haven't refreshed my memory recently on the minimum wage, but what I'm saying is that use your church mind and pay net now. How much is it? Don't mind me, Mr. Adeosun. So most people have said it is gross, but I mean, if I'm going to use my church mind, let the person at least be able to buy shawarma. Don't pay his shawarma money to government as and then when you even say gross and net, I believe there are some restrictions about even the taxation of the minimum wage. I'm not sure, but I've not encountered it very recently, so I don't want to say what I'm not sure about. But if the minimum wage is supposed to be non-taxable, that's the lower bands, then we can't even be talking about net and gross in these situations. Again, I'm not sure, so I don't want to. So Uncle K says it is non-taxable. So if it's non-taxable, then the issue of gross and net would not even come in. So over to you, Dr. Adeosun.
All right. Thank you so much. You have done a yeoman's job. Excellent. You have over-delivered. Ladies and gentlemen, let us unmute and let us thank our facilitator.
Fantastic, fantastic,
We
Emmanuel
are
Braye.
joining the courts.
Fantastic.
Thank you. Please, I have a question. Thank you. But I had a question. No, I wasn't allowed to talk.
Thank you, sir.
Thank you. I will need to reward
Thank you,
the
sir.
recording
Thank you so
session
much.
tomorrow,
Thank you,
and
sir.
I
This
get
was
every
awesome.
aspect
Please, I have a
of the seminar.
question.
Thank you, doctor.
you. Very insightful. Thank you so much.
Thank you, everyone. Thank you.
Let's just take that.
Okay, go ahead with your question.
Good evening. Thank you, Mr. Emmanuel.
Yes, good evening. Thank you.
So, I used to work in an organization where all the staffs they started recruiting recently. They made all of them contract staff. As soon as you come, contract staff. And I think
please go ahead with your question.
Contract staff, I think they say till like 2 years, where they now make you a full-time staff because according to them, because of the attrition rate in the industry they operated in, and also to reduce tax burden. What would you advise?
I would advise that practice is an unfair labor practice. It is better for you to create a retention policy than to go about it that way. If you want to, if you cannot casualize people simply because sometimes your practices, your company's internal practices will just eventually turn out being
Say again, I stand with you. I'm just-
evidences of unfair labor practices, right? So you want to make sure that you're not caught in that ticket. So don't casualize workers simply because you don't want them to use your money to jackpot. Not you, I'm talking about the organization you are talking about. It's best for them not to do that. Employ them as full-time staff. Create a separate package as a retention, policy that you have in your organization that people can aspire to in the next 2 years. Oh, I will get this. And then you amortize that. If you say, for instance, if you stay in this organization for 2 years, you're going to be entitled to, let's say, a grant of 5 million naira. Everybody has that to look up to. And then you pay that money. You can now amortize it again over a period of 2 years. You've gained an employee for 4 years instead of using, you don't have to be a man of war every time. Sometimes you have to be a man of love, sometimes. So maybe you tell the organization to do that. And I hope that answers your question.
All right, thank you. Thank you so much.
You're welcome. Thank you very much.
Sorry, please. I'm so sorry. I had written
Alright.
in the chat box that I wanted to ask a question. I wanted to
okay.
raise my hand, but it wasn't possible for me to do so.
No problem.
All right. So the question is, contract staff outsourced actually, like the drivers, the security people, and the cleaners. And so
Thank you and good night. Bye, everyone.
Oh.
All right.
Oh. Okay. Thank you.